Hi, Kevin Lemley, criminal defense lawyer here in Central Arkansas. Offices in Little Rock, Cabot, and Searcy. Talking today about the motion to suppress. And a lot of times, this is one of the strongest weapons that we have here. And it's a tool that we want to look at in every single case. We don't always get to use it, but we certainly want to look at it. So what a motion to suppress does is it says, all right, state, you found this evidence. It's incriminating on my client. They found a gun, they found drugs, whatever. And so they're going to be able to use that evidence. You're probably going to be found guilty. So what we want to do with a motion to suppress is we want to say that that evidence was obtained illegally. So maybe it was an illegal stop. Maybe there was no basis to begin with the stop in the first place. Or we can say it was an illegal search. Maybe they had a basis for the stop, but maybe the basis was gone by the time they did that. Or maybe they went beyond the scope of what would be reasonable in that situation. There's a lot of case law and a bunch of nuances to it, but basically we're looking for any way that we can say that the way the police got the evidence, it was obtained illegally. And then if we're feeling really good about it, we're going to file what's called a motion to suppress. And so with the motion to suppress, it says, all right, judge, they've got this harmful evidence, but they got it illegally, so we want you to suppress it, and so they can't use it at the trial. And so with a lot of cases, if we win the motion to suppress, we're going to ultimately win the trial. Because, take like a drug case, they found fentanyl or whatever they found on you. If we're able to prevent them from using the fentanyl, the case just completely dies. Now, we have to be strategic with how we do this. We want to look at it early, get a handle early on. Do we have any suppression issues? Is there any way to beat this evidence? But we're never in a hurry to go file it. And the reason for that is a lot of prosecutors will use a penalty on you if you file the motion to suppress. So what they'll do is they'll say, all right, here's a plea offer we're going to give you. It's probation only. There's no chance that you're going to prison. You're like, all right, we like that. Well, then we filed the motion to suppress, and they go, well, if you make us do the suppression hearing, that deal comes off the table. And White County is really bad about that. So we have to be strategic about whether or not we're going to file it and then when we're going to file it. Because if we know we have that situation like that, we want to game it. We want to file it right before a pretrial setting. That way we can kick the case down the road a couple of months to buy us some more time on it. Now, if we feel really, really strongly about it, then we're going to press it and proceed with it. The hardest part with the motion to suppress is it's never a given that it's going to work. We've had situations where it was really kind of on the bubble in the case law. We really didn't feel that great about it, and then it got granted. And then we've had other situations where it looked to us like the fact pattern fit dead on the case law, and it got rejected. They allowed the evidence in. We can look at everything and give you our best judgment, but at the end of the day, you don't know how that judge is going to rule until you get in and you have the hearing and he makes his ruling on it. So that's why we have to be careful with the motion to suppress. We want to look at it early. We want to see if you have a good suppression issue to raise, but then we got to think about how best to raise it and when. And we want to get those offers in hand, generally speaking, before we file it, because we want to make sure we're not getting a penalty just for filing the motion to suppress. But if we got a case, there's really strong evidence against you, then the first thing we want to look at, is there any way that we can suppress it? Is there anything that the police did wrong? In some situations, that does give rise to a possible civil lawsuit that we might be able to raise down the road. But we can visit with you on that more if that's the case with you. But the motion to suppress, something we want to look at in every case. If we win it, we're probably winning the case. Thanks.